And a very good morning to you, John Fradgley from the Bell Legal Group, back with you for another program of The Law and You this Tuesday morning. Your opportunity to get free legal advice. All we need you to do is get on the telephone as soon as you can. 55208888 is that number. Again, 55208888. 07 if you live south of the Tweed, but otherwise you'll get straight through. Don't forget, of course, we also do have our Talkback email address, which is talkback@4crb.com, if you're not in a position to make a call. But we do have a caller online who's been waiting there very patiently, and so we say a very good morning to Lynn. G'day, Lynn. How are you today?
I'm fine, thanks, John.
Lynn, are you there?
Yes. Hello.
Hello.
Hello. You can hear me?
Oh, yes. Sorry, one of my headphones is not working, but I've got them both on now, so I can hear you properly. How are you today?
That's all right. I'm well, thank you very much.
That's good. How can I help?
I just have a query. If you could explain what the law is on fencing between two houses, it's on top of a retaining wall.
Right. Okay.
Right.
All right. So where there's a retaining wall involved, it does become a little more complicated. But basically, the law for, is this in Queensland? Is it?
No, it's in the Tweed.
In the Tweed.
In the Tweed, yes.
Okay, right. Well, look, I'm not 100% sure what legislation applies down there. In Queensland, it's the Neighbourhood Dispute Resolution Act, which now covers dividing fences. But I'm fairly sure the basic concepts are the same for New South Wales and for Queensland. So basically, if there is no dividing fence between the two properties, then you obviously the first thing to do is to talk to the neighbour about fencing and what sort of fencing you would like. If you're unable to
we have a fence.
There's an existing fence, is there? And are you wanting to replace it or improve it or what?
Well, it's nearly had it.
All right, okay, so that would be the repair of a dividing fence. Okay, so, and what about the retaining wall? Is the retaining wall in good condition?
Oh, that's fine.
Okay, all right, so it's just the fence. Okay, well, again, the relevant legislation down there also covers the repair of dividing fences, as it does in Queensland, where they require repair. And again, the first thing to always do in these situations is to try and discuss it with the neighbour and discuss what sort of a fence you would like to put in place if it's so badly in such bad repair that it needs replacement, or alternatively how it can be repaired if you and the neighbour consider that it can be repaired. You then reach an agreement if you can, and that should always be put in writing between the two of you, that you're going to split the cost presumably equally. You get some quotes for the repair. Then you and the neighbour agree on which quote you're going to go with. And then again, at that point in time, I would suggest that you just record it very simply in writing that you've agreed you're going to get the repairs done by this particular, or the work done by this particular tradesman. The cost is X, and we agree that it'll be split equally, and we'll each pay half the bill. And then engage the tradesman if you can, so that both of you are liable to the tradesman for the work. If you can't reach agreement, either as to repair or replacement, then you will probably have to end up going to it's basically like the small debts court. In Queensland, it's called the Queensland Civil and Administrative Tribunal, and I'm pretty sure in New South Wales they have the same. So it's the New South Wales Civil and Administrative Tribunal, which deal with claims in relation to dividing fences. And normally you can pick up the forms for that at the local courthouse if you need to go to that point. Right. And now, if you do need to, if it does get to the point where you're going to have to do something like that, what I would suggest you do would be to perhaps speak to the Gold Coast Community Legal Centre and Advice Bureau. They visit a number of centres up and down the coast, including Coolangatta. Now, and although it's Coolangatta, obviously practitioners in Coolangatta are quite familiar with the legal matters in New South Wales, and so you could ring their office, which is 55329611. So that's a Queensland number. The number again, 55329611. Find out when they're going to be down in the Coolangatta area, and you could then go there and you could see them and get some advice on how you can bring a matter before the appropriate tribunal to have that sorted out.
Right. See, the main problem is the person next door just says, "Oh, fences. Nothing to do with me, the fence. Nothing to do with me."
Well, if that's what they're saying, then I would suggest that you're going to have to give them a notice to fence. So you're going to have to get the quotes for the work.
Yes.
You need to give them a fencing notice under the relevant legislation down there, and then the correct name of the tribunal down there, it's NCAT. NCAT, but I'm fairly sure you would be able to pick up the forms from the courthouse, or alternatively you can pick them up online. So if you're computer literate, you could search the NCAT and also the New South Wales Civil and Administrative Tribunal. So that's basically the organisation. NCAT is the New South Wales Civil and Administrative Tribunal. There is a phone number here for them that I have, if you'd like that number.
Yes, I'd like that, yes.
Mm-hmm. So their number is 1300
yes.
006
006
228.
228.
Yep. So give them a call, and you might be able to have a chat to them. Otherwise, you could certainly contact the Gold Coast Community Legal Centre and Advice Bureau and find out when they're next going to be in Coolangatta.
Yes. Okay.
All right then.
John, yes, I was just wondering, you can't seem to get a hard and fast rule either here or in Queensland, so just trying to sort it out.
Yes, no, well, I think if you were to contact NCAT on that number I've given you, that might be the best best start. All right then.
Okay, then thank you very much, John. I appreciate your time.
Okay, no trouble at all. Lynn, all the very best. Time on 4CRB is just past 13 minutes past 9. That's, of course, past 10 south of the Tweed. Oh, I didn't get the name of our next caller. Janine, good morning, Janine. How are you?
Well, thank you.
That's good. How can I help?
It's a body corporate question.
Yes.
If an owner rents a unit in a small complex to a tenant and the tenant is a problem, can the body corporate hold the owner responsible legally?
Well, there's an obligation on the owner to ensure that their lot is used in compliance with the body corporate bylaws and the relevant legislation. So this is in Queensland, is it?
Yes, it is.
Okay, and is the tenant in there through the manager of the complex, or is the tenant in there directly through the owner of the unit?
The tenant is there through an agent.
Mm-hmm.
The tenant has caused problems. The agent is dealing with the normally.
Sorry, Janine, you're breaking up quite a bit. It's very difficult to hear what you're saying. I'm sorry.
Okay, can you hear me now?
A little bit better, yes.
Okay, the tenant is in there through an agent.
Mm-hmm.
The tenant is causing problems.
Right.
The agent is taking the required steps to deal with that by law.
Mm-hmm.
But in the interim, can the body corporate deem that the owner is responsible if they are taking the necessary action to have it rectified?
Well, I suppose it really depends on what's happening. I mean, if the tenant, for example, is causing damage to the common property or body corporate property, then obviously that would be a cause of action against the tenant personally rather than against the owner. So the only thing that the body corporate could possibly do against the owner would be to issue a notice to the owner if the behaviour of the tenant is not in compliance with the bylaws of the body corporate or some other provision of the legislation. The body corporate could give notice to the owner in relation to that. And as to what action or what liability could flow to the owner through the owner's fail to act expeditiously to resolve the matter, well, that's really, unfortunately, going to depend on the circumstances, Janine.
Right, okay. Yeah, that clarifies a lot for.
Yeah, so obviously getting the Secretary of the Body Corporate to write to the owner to make the owner aware of what is going on is always a good thing to do, because the owner may be completely unaware if the agent hasn't let the owner know what's going on.
Yes, no, I understand.
Yeah.
All right, thanks
All
very
right.
much.
Okay, Janine, all the very best. And the time on 4CRB is just coming up to 16.5 past 9. That's, of course, past 10 on the Tweed. And we say a very good morning to Deb. G'day, Deb. How are you today?
Hi, good morning. Good, thanks. Good. I just wanted to ask a question about an enduring power of attorney.
Sure.
But it's in relation to a New South Wales property, and it's a New South Wales power of attorney.
Right,
Can you help me
okay.
there?
Yep.
Yeah, just a basic question. So it's a long story what I don't want to go into, but so this girl, which is my son and his wife, so she's now become paraplegic and virtually and kind of mentally unbalanced.
Mm-hmm.
So she's given her mother power of attorney to handle her affairs, obviously.
Mm-hmm.
But I was just wondering, because the unit's in joint names between my son and his wife, which is still married, can this power of attorney take part, because the unit's in joint and they've got joint bank accounts where joint bills come into and joint money needs to be paid out of the joint bank account, and they're getting rent for the unit now. So I'm trying to understand if this power of attorney can, what they're trying to do is take half the rent and put it in their own bank account, not into the joint bank account.
Right,
So
okay.
therefore, makes it hard for our son to pay any bills.
Right. Well, obviously the bills for the property need to be paid as a first priority. How was the mother appointed as the attorney? It sounds to me like, has she been appointed as an administrator and a guardian, has she? Was your daughter-in-law sufficiently competent to be able to make a power of attorney?
Yeah, well, that's what they've done. I think they've said she's sufficiently competent, and it says my attorney may exercise the authority conferred on my attorney by Part 2 of the powers of attorney.
Yes.
So
your son and his wife still together?
Yeah, well, no, they're not together. No, they're separated.
All right. Okay. For any money to be removed from the joint bank account, that's going to require either joint signatures or it's going to require a court order. Presumably your daughter-in-law, I assume that your son and your daughter-in-law were both signatories on the account?
Yeah, I believe so.
Yeah, what your son should be doing is advising the bank and changing the authority to operate on the account so that it requires both signatures, that the attorney can't sign to remove any funds from the account in place of the wife. I would expect that a bank would be very reluctant to make that or to allow the attorney to remove funds on behalf of the wife, but nonetheless,
the attorney's trying to stop the real estate agent from putting money into the bank account. She's telling the real estate agent to only put half the rent into her account or her daughter's account. We've just got a problem with that. We told the real estate agent, no, that's not right. We go into the joint account.
So who pays the bills in relation to the unit?
Our son, the joint account.
Well, the other option is to instruct the agent to pay all the bills, and so he then accounts for the net, half the funds to your son and half the funds to the wife, because the expenses of the unit must be paid as a first priority. So that might be another way of solving the problem, Deb, would be to come to an arrangement where the agent pays all the expenses and then each party gets half the funds.
They haven't got an agent. Yeah, they haven't got an agent. It's a long story, but.
Well, I thought you said just a moment ago that the money's going to the agent, and now the agent, this person's trying to make the agent pay the money half and half.
No, it's a strata manager. It's a compensation claim. So the strata manager's got to pay rent as compensation claim, and the mother, Janice's mother's acted on this power of attorney, instructing the strata manager not to pay to pay half the rent into her account instead of going into their already joint account. So I was just wondering if she can use that power of attorney to tell that strata manager not to do that, or if she's interfering, or if she's used the power of attorney out of order.
Well, no, she certainly hasn't used the power of attorney out of order. She can do that. But, I mean, you obviously need to have a clear understanding with the attorney that the expenses of the apartment must be met first before the net proceeds are divided. So if
that's
it's
right. That's
if it's
the problem. They don't want to do that. They won't meet their commitments. They won't pay. Our son's been having to pay everything out of his own pocket.
Well, your son then may have to seek an appropriate order from the court in relation to it, because the expenses must be paid. The other option would be whether So it's not actually rent that's being received?
It's compensation rent. It's not rent from a tenant. It's rent that a strata manager's got to pay as compensation because the unit can't be rented because of a problem that they've never fixed over the last year, and now there's an NCAP order to get the problem fixed. And in the meantime, the strata manager's got to pay rent compensation to them because they can't live in the unit and they can't sell the unit.
Right, okay. Well, as I say, look, the expenses definitely need to be met. So I think if you can't get if you can't get an arrangement with the attorney that the expenses will be met before the money is divided, then I think, unfortunately, the only thing you can do is bring an application to the court. Whereabouts does your son live?
Yeah, well, he's actually living back here with us now in Queensland.
But where's the unit?
Yeah. In Sydney.
All right. Okay. Well,
North Strathfield.
Yeah. Look, the only thing I could suggest that you get him to do would be whereabouts on the Gold Coast are you? Which suburb?
Miami.
Right. Okay. Well, look, he could go to the Robina, or it's now called My Community Legal, which was formerly the Robina Community Legal Centre. Out at the Gold Coast City Council Robina Community Centre. It's just on the western side of the road from the Robina Town Centre.
Oh yes,
I'm
familiar with where it is. Yeah,
it's open from 6:30 to 8:30 on a Thursday evening, so he could go there. Or the other alternative would be to ring and go and see the Gold Coast Community Legal Centre and Advice Bureau. I can give you a phone number for them if you like.
Okay, yes. Mm-hmm.
So their number's 5532 9611.
9611, and they'll help with the Queensland, with the New South Wales.
Yes, they should be able to assist you, particularly Gold Coast Community Legal Centre and Advice Bureau, because they do have a visited centre down at Coolangatta, which I'm fairly sure most practitioners in Coolangatta are admitted in both Queensland and New South Wales. One of them would hopefully be able to assist.
Oh, that's great. I really appreciate your help. Thanks very much.
Okay then, Deb.
Thank you.
All the very best. And the time is 24 minutes past 9. We'll be back after this word from our sponsor.
Great deals on home appliances, plus bonus gift cards at Harvey Norman. Shop our latest catalogue and receive bonus Harvey Norman gift cards on a huge range of small appliances. Up to $100 on vacuums, up to $200 on coffee machines, bonus gift cards on washers and air conditioners, up to $250 on ovens, up to $400 on fridges. Great deals across home appliances, plus bonus gift cards on selected products priced from $200. Conditions apply. See store for details. Limited time only at Harvey Norman.
A sponsor.
AMP Advice want to help you determine your retirement number and retire right. Whether retirement involves travelling, community involvement or caring for family, call AMP Advice today on 5554 1000 to discuss making your ideal retirement a reality.
And the time is 25 minutes past 9. We have an email that came in from Anne, and it relates to an issue concerning overhead or overhanging branches, I should say. Unfortunately came in last Monday, but somehow, or Monday week ago, but unfortunately got missed in the system somehow. So my apologies, Anne, for not dealing with this last week. But basically the situation is that Anne lives in an area where her neighbour has a large number of branches that from a tree that overhangs overhang her property, and they drop a lot of leaves and other debris along her back fence. And she was wanting to know whether she can cut back the overhanging branches, and if so, what then should be done with those. So this is governed in Queensland by the Neighbourhood Dispute Resolution Act, and basically where branches are overhanging, you're entitled to cut those back. Obviously, as I was saying earlier about fencing disputes, it's always advisable to try and discuss these matters and reach a resolution or an agreed way that the problem will be dealt with a neighbour before proceeding to take action. And Anne has endeavoured to do that, but has finally had to cut them back because they couldn't receive any communication from the neighbour. So she now has all these lopped branches that are in her yard and is asking what to do with them. Now, under the law, there's no longer a legal requirement to return those branches to the neighbour. Back under the old Dividing Fences Act, which previously dealt with fencing disputes, and under the common law, there was an obligation to return the branches to your neighbour, because that all goes back to the days when wood was a valuable commodity and people would be using it in their combustion stoves, in their homes, etc. Those days, of course, are long gone, and most of the overhanging branches today are probably off shrubs and trees that don't really burn that well anyway. So these days, although you're still entitled to return the lopped branches to the neighbour's property, I really feel that it's not a very neighbourly thing to do with them. And so my advice to people is that if you haven't been able to reach resolution with the neighbour and you've cut back the tree in spite of the neighbour either protesting that you shouldn't cut it back or alternatively simply not communicating with you, it's almost like throwing petrol on a fire, I think, to throw the branches back over the fence. And so my recommendation to people in these situations is, look, simply if you've cut the branches back, you've achieved the objective that you want, then simply arrange to get them taken away, or if you can cut them up to a size where they can go into your green waste bin, all the better. But throwing them back over the fence, I think, can probably only tend to aggravate an already difficult situation between you and the neighbour. So, Anne, my advice would be that if it's not too difficult for you to take those items, either put them in your recycling bin, the green waste bin, or alternatively take them to the dump if that's possible for you to do. Well, thank you to all the people who rang in today to make for such an interesting program. I'll look forward to being back with you, of course, next week for another program of The Law and You. But as always, until then, it's goodbye and God bless.